Yes. Yeah, which section we were covering? Any idea, Kumar?
Sir, we were doing presumptions under may presume, shall presume, and then section 85, 84.
So have we covered the entire shall presume or not? What is the last section I covered you?
Sir, 85.
85.
85, 80.
Okay. Okay.
I
Okay.
think we
I'll
have
let.
completed
Yeah.
presumptions.
Yeah. Yeah. Presumption में yeah. Shall presume के अंदर मैं ले रहा हूँ आपको. Yeah. Because may presume तो check कर लिया आपने. Various example 85. Yeah. 85, 85A, 85B, 85C. They and 85C, 85A से लेकर C. These are regarding electronic agreements, electronic signature, and electronic certificates. Please note that. उसके लिए इंफॉर्मेशन टेक्नोलॉजी एक्ट रखिए आप. याद रखिए. And इसके अंदर if it is a original one, it will come under the provisions of section 65A. Please maintain. Original means the certificate which is original has been sent to you by the officer, or certificate the signature is original. It is a original which can come under the provisions of section 65A. Secondary evidence खोल लीजिए आप. This position has been clarified by the Supreme Court in Arjun Pandit Rao's case. वो judgment मैं आपको बताता हूँ. Arjun Pandit Rao का very famous judgment of 5-bench judgment of the Supreme Court. Please remember this. What is 65A, 65B? ये judgment आप next time मैं explain करता हूँ. All of you जिसको circulate कर देना. Judgment authored by Justice Nariman, Rohit Nariman, on behalf of the other 4 members of the bench. It's a constitution bench judgment overruling at least 3-4 previous judgments. मैं समझाऊंगा. 65A deals with the electronic evidence relating to electronic record. 65 deals with the admissibility of electronic record, secondary evidence, which law mandates that under subsection 4 you are required to obtain the certificate. See, in any proceeding where it is desired to give a statement in evidence by virtue of this section 65B, मैं पढ़ रहा हूँ. Just open section 65A पहला to understand the electronic evidence, how the court shall presume or may presume. The 65A पहले पढ़ रहा हूँ मैं. The contents of electronic record may be presumed in accordance with the provisions of 65B. Okay, 65B, let us see that. Notwithstanding anything contained in this act, any information contained in the electronic record, which is printed on a paper, stored, recorded, or copied in optical magnetic media produced by computer as to the computer output, shall be deemed to be also documented. So यहाँ पे the definition of a document also covers the computerized document. See, आपने सीखा है under section 3 what is the meaning of a document. The document also includes the computerized version of the record. Then see, उसके बाद ये कहता है, if the conditions mentioned in the section are satisfied in relation to information computer in question and shall be admissible in any proceeding without further proof or production of the original as evidence of any content of the original or any of the facts stated therein, which direct evidence would be admissible. So if 65B का compliance रहेगा, secondary evidence would be admissible. इसके अंदर conditions are given in 65, 65B, 65B2, 65B3, B4. Today I am just dealing with the 4th condition. Kindly see that here. In any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing the following thing, that is to say, identifying the electronic record, containing the statement and describing the manner in which was produced. For example, you have sent a WhatsApp message, email message, हाँ, वो transfer किए. अभी many times there are election while taking place. You know that बहुत दंगेबाजी होती है हमारे country के अंदर. All political parties keep abusing each other. बहुत commotion होता है. Under the Representation of People's Act, you cannot be abusing this your authority, your permission during election time. But one of the contests, both the parties, they take videograph of the commotion taken and the atrocities which are indulged by the other party to show before the court of law while challenging the election petition under section 99 and 100 of the in Representation of People's Act. All of you know that. So one such matter which went to the Supreme Court ultimately was from Bombay High Court, Arjun Pandit Rao Khotkar's case, a landmark judgment. All of you should read and come next time. I will explain. उसके अंदर ये प्रोड्यूस सर्टिफिकेट चाहिए. Item number identify. Number two, giving such particulars of any device involving the protection of the electronic record as appropriate for the purpose showing that electronic code was produced. Now C, dealing with the matter to which condition mentioned are and purported to be signed by a person occupying a responsible official position in relation to the operation of relevant device, or the management of the relevant activities, whichever is appropriate, shall be evidence under of any matter, shall be, underline the word, shall be evidence of any matter stated in the certificate, and for that purpose, this subsection, it shall be sufficient for the matter to be stated to be best knowledge and belief of the person stating it. So यहाँ पे shall presume में आ गया. The moment a certificate is obtained by any of the parties, many time अभी police officers are conducting investigation under the CRPC scheme. They take photograph, they take videography, they email messages लेते हैं, they take your mobile phone. ये सब के लिए चेक करो आप. They are required to produce certificate under section 65B of the information technology of the Evidence Act, read with the Information Technology Act. मैं पढ़ाऊंगा ये next time when we deal with this. So without the certificate, once the certificate is obtained from the Information Technology Officer, the court shall presume that the evidence is admissible. This is very interesting. Admissible. Otherwise, if you don't bring the certificate, your email messages, your WhatsApp messages, and your CCTV camera messages, they have zero evidentiary value. ये जजमेंट पढ़ेंगे आप अर्जुन पंडित राव खोटकर केस. उसके अंदर बहुत सारे सुप्रीम कोर्ट के जजमेंट क्या विल कर्सरली टेक वन जजमेंट थ्रू. उसी दिन अब डीलिंग करेंगे आप. So this is another example of a shall presume under the provisions of section the provisions of section 85 ABC ABC of the Evidence Act. Yes. Now come to the next section is very important. 86 presumption. Presumption as to certified copy of foreign judicial record. Now foreign judicial record CPC में पढ़े आपने. Foreign judgment is not conclusive पढ़े आपने section 13 के अंदर. Section 14 कहता है कि foreign judgment they shall be admissible in the court of law. If you have a look at the code of civil procedure, I will just point out to you again. थोड़ा CPC खोल लीजिए इसके. और foreign judicial record के लिए it is more appropriate to know at this stage. CPC section 13 and 14 खोल लीजिए. Of course, you read it last semester. भी शायद भूल गए होंगे भी. मैं भी भूल जाता हूँ कभी कभी. So better to refer to the bare acts and books and keep it ready with you. See, when foreign judgment not conclusive is given, so under the scheme of the Evidence Act, mean the court requires evidence. Not conclusive mean in evidence which is conclusive, you don't require evidence. You don't need to examine the maker of the document. But when the document is may presume, shall presume, normally if it is challenged by somebody, that the order has been obtained fraudulently, surreptitiously, without serving the writ of summons, and you have a right to challenge it and before the court of law, and you must examine the persons who are concerned. Copy नहीं मिला. Now section 14 पे आ जाइए of the CPC. Presumption as to foreign judgment. अभी देखिए 86 में पढ़े हमने. The court shall presume upon the production of a document purported to be the certified copy of the foreign judgment. Now, when a certified copy is produced and how he is dealt under Section 86 of the Evidence Act, I will come to it. Okay? The court shall presume upon production certified copy of one judgment that such document was pronounced by the court of competent jurisdiction unless the contrary appears on the record, but such a presumption may be displaced by proving want of jurisdiction. So one of the party may take up the plea. आपने Arbitration Conciliation Act में check करें आपने, when we dealt with the New York Convention and the New York Convention as well as the Geneva Convention के अंदर the award which may be passed by a foreign judicial tribunal tribunal is not conclusive, not binding upon the Indian court if it is the judgment is passed without hearing the defendant. It is mandatory because the principles of audi alteram partem, namely natural justice, must be satisfied. अगर वो comply नहीं करें, आपको summons नहीं दिए हैं, the entire order is vitiated. It suffers from the vice of nullity. Even in the Indian courts, also same principle applies. We are following the Anglo-Saxon rule of law. Plaint file करने के बाद you are supposed to serve the plaint and writ petition, copy of the plaint summoned under Order 5 and Section 27 of the Code of Civil Procedure upon the other side. Similarly, आपने criminal complaint भी file किया, defamation का कुछ भी under Section 190, the CRPC, magistrate passing an order taking cognizance, you must serve the writ of summons under the provisions of the CRPC through the concerned police officer station upon the accused person. अगर वो नहीं करे, service करे, your complaint is liable to be dismissed. So that is the similarly a foreign judgment which has been produced. Foreign judgment is not conclusive ipso facto. अगर वो एकदम produce करेंगे आप, court इनकार करेगी लेने से. The court will not take cognizance of the copy as a gospel truth. You have to prove it in a manner as the Evidence Act. Our Evidence Act says that obtain certified copy from the foreign country. Maybe an award is passed in UK, USA, or any other country. India is signatory with the foreign country. वो करेंगे तो produce करके लाइए. Then the Evidence Act Section 86 says the court may presume that a document purported to be a certified copy of the judicial record. Any country not forming part of India or Her Majesty Dominion is genuine and accurate if the document purports to be certified in any manner which is which is certified by any representative of the central government. So it must be the document आपने certified copy ले लिए UK America में, you will not straight away bring it to India. You will have to go to the Indian Council, the Indian ambassadors of the Indian company, and the council के पास जाके आप sign ले लेंगे. Please note that here government in such our country, वो country में जाके अगर USA से record produce कर रहे हैं आप, many time husband and wife got married in India and divorce is taken place in a foreign country. Then custody के battle में some property in India battle में शुरू हुई, यहाँ भी प्रॉपर्टी का डिस्प्यूट हुआ, वो बोलेंगे डाइवोर्स हो गया, प्रोड्यूस कीजिए आप. सर्टिफाइड कॉपी अप्लाई करने के बाद यू प्लीज गो टू दी इंडियन एम्बेसी इन यूएसए और यूके वेरेवर, वहां पे उनका सर्टिफिकेट चाहिए, सर्टिफाइड कॉपी फ्रॉम द कोर्ट इन यूके या यूएसए फॉरेन कंट्री जहां से भी डिवोर्स लिए हैं आपने या आर्बिट्रेशन अवार्ड भी लिए हैं. When you want to file it for execution in India, in the Bombay High Court, Delhi High Court, or any district court may, because normally foreign awards are executed in Bombay High Court and Delhi High Court. These are they contain specific rules for foreign awards. ये सब जानना चाहिए आप. You cannot go to the normal civil court for execution. तो उसके लिए certified copy लेने के बाद you will have to go to the embassy of India in that country. वहां से सर्टिफिकेट लीजिए आप. दिस इज द सर्टिफाइड कॉपी. यू दिखाने के बाद कॉपी मांगेंगे. लाइक ए नोटरी इन इंडिया, यू हैव गॉट ए मैरिज सर्टिफिकेट, ओरिजिनल डॉक्यूमेंट, वो दे के कॉपी दे के आपको ट्रू कॉपी करते हैं. सो इट शुड बी ऑथेंटिकेटेड बाय द इंडियन ऑफिसर सी कंट्री टू बी द मैनर कंप्लाइंग यूज फॉर द सर्टिफिकेशन ऑफ द जुडिशियल रिकॉर्ड. So the judicial record is to be certified twice by the court of law which has passed the order. And secondly, if you want to bring that document and use in judicial proceedings in India, you have to go to the Indian embassy in that particular country and take the second signature. अगर वो नहीं लाएंगे तो आप your document will not be admissible. Court will not presume it to be correct. Please remember this document, very important. Another important document, then section 87 कहता है, 87 also deals with may presumption. The presumption as to books, maps and charts. The court may presume that any book in which it may refer to information of the matter or a public general interest and the published map or chart settlement of which relevant fact and which is produced for inspection was written and published by any person at the time of the place which it is at which purported to have been written published. So when any document or a book is published, when you want to establish a particular custom in a community, there are many authors have written कि हिंदू लॉ के अंदर क्या कस्टम है, मोहम्मदन लॉ में क्या कस्टम है, क्रिश्चियनिटी में, जुडाइज्म में क्या क्रिश्चियन है, उनके बुक्स, authentic books can be referred to. The court may presume that what the learned author has written is correct here. So unless the chart is proved, the maps also prepared by the government of India, even prepared by the foreign countries, are to be proved in the same manner. Then 88 speaks of presumption as to telegraphic messages. Abhi telegraph to chale gaya, abhi other messages. The court may presume that a message forwarded from a telegraph office to the person whom telegraph message address corresponds with the messenger delivering to the transmission from which so and so, but the court shall not make any presumption as to person by whom such message was delivered for transmission. अभी टेलीग्राफी से इंडिया में अबॉलिश हो गया, ये सेक्शन 88 की अहमियत कम हो जाएगी, बट द कंट्रीज एंड द प्लेसेस वेयर इट इज देयर इट विल होल्ड गुड. नाउ 88A चेक कर लीजिए. प्रिजम्पशन एज टू इलेक्ट्रॉनिक मैसेजेस. The court may presume that the electronic message is forwarded by the originator through the electronic mail server to the addressee to whom the address purported to have been addressed correspond with the messages as fed in the computer for transmission, but the court shall not make the presumption as to the person to whom such message was sent. So अगर मैंने आपको मैसेज भेजा, आपने मैसेज भेजा कि लेक्चर के बारे में ये तो मैं, so your messages are with me. A legal notice दी आपने on behalf of your client, a lady against a husband for a divorce. वो बोले from your email of a lawyer, वो मैसेज पता ये ट्रांसमिट होएगा, that you will have to transmit the message and make a statement and also obtain a certificate under section 65E, 65B, subclause 4 of the Evidence Act, right, with the Information Technology Act. ये particular message notice हमने भेजी है particular lawyer के email से, इनके computer से वो certificate. So as regard the person किसी को भेजा है, not necessary, but आपके computer से गया है is more important. It is who has read it, who has not read it. Defendant cannot take up the claim. मैं नहीं पढ़ा हूँ, तुम्हारा number तो है. Your wife must have read it. Your employee must have read it. Your agent must have read it. So transmission of the message is more important than the receipt itself. Need the explanation check कर लीजिए आप. For the purpose of this section, the expression addressee and originator shall have the same meaning respectively assigned to them in clause B and ZA of the Information Technology Act. So Information Technology Act, certain provisions are to be required to be read in consonance and in conformity with the provisions of the Evidence Act, and they cannot be read in isolation. Please note that here. Then 89 check कर लीजिए. Presumption as to due execution etc. of a document not produced. The court shall presume, देख लीजिए, ये shall presume. The court shall presume that every document called for and not produced after notice to the produce was attested, stamped, and executed in the manner required by law. So you are filing a suit on the ground that the builder has not given you possession. Huh? There was an agreement of sale between the plaintiff and the defendant builder. Builder has taken your signature, took you to the registration office. Since all monies were not paid, original was lying with him. But right now, to prove the DO execution and agreement, you have a copy, you may be having an ordinary unsigned copy. So not to worry. So unsigned copy bhi parenge aap, because the suit for specific performance can be filed even upon a oral agreement. Please note that. And there is a specific explanation under section 49 of the Registration Act, which says that effect of non-registration. If a document is not registered, the agreement is not admissible. The document, the court will not take into record. But explanation check करेंगे आप for collateral purposes and for filing suit for specific performance, you don't require it. do inquiry, but you're claiming damages and other incidental relief. So document plaintiff के defendant के पास है, तो आप क्या करेंगे? You will give a notice under section 66. मैं पढ़ा था आपने, so don't tell me what is section 66. Section 66 says that here, when the original document is not in your possession, rule as to notice to produce. Please remember this. This sections 89 to be read along with section 66. When you have only a copy, you call upon the builder that the original document is in your possession. I am now tender evidence in chief in before the court of law, and the court has kept the matter for marking of the document, which marking takes place under section 136 of the Evidence Act, read with order 13 of the Code of Civil Procedure. On that day, you are requested to come bring the original document so as to enable the honorable court to mark the document as exhibit and take the same on record. अगर वो नहीं produce करा, तो another provision for giving notice is, please remember there are two more provisions in the one code gives it, and also the other side. I am bound. अभी section 66 पढ़े, that relates to the secondary evidence you have. The primary evidence is with the builder at the other side. Now the next provision in the Evidence Act, any other document apart from the apart from Xerox copies or any other document, तो उसका भी provision आपको बोल देता हूं मैं, आप देख लीजिए. Then that section is a please open, because the section 89 has a direct base. Yeah, section yeah, section 89 has a direct bearing to that. Section 89, no? Yeah, section 89 has a direct bearing to this notice provision, which is in पढ़ देख लीजिए आप, section 163. Section 163, giving as evidence of document called for and produce on notice. So while the defendant may be in cross examination, for cross examination you may ask question to him, apart from the suit premises, how many other properties you have got? आप ये सवाल पूछेंगे उसको, तो मेरे पास he will say that, because normally in a motor tribunal cases, rent control legislation, or in civil cases, you claiming damages, you give notice to other side. You are hereby called upon to file affidavit and give details of your properties. If you are a landlord filing a suit for bona fide requirement of a tenant, tenant is a rich man having a lot of properties, you suppress it. आप बोलेंगे नोटिस देंगे, आप ये नोटिस आप दीजिए 163 के अंदर. You are hereby called upon to produce as to how many flats you have got. You are hereby called upon to produce and inform as to how many cars you have got, your bank balance, your fixed deposits, your insurance, your children's affidavit, your children's record. ये सब चीजें मांगना पड़ेगा आपको. Please note that this is the job of a good cross examiner. Just because paper आए lawyer बन गए नहीं चलेगा आपको, ये preparation करना पड़ेगा आपको. ये notice देंगे आप section 163 के अंदर. So I am not talking of the notice under 66. That is related to only secondary evidence and primary evidence document. Now general document के लिए आपको produce करना है, cross examination में इसको impeach करना है, because the defendant has not produced the many document, he has suppressed from the court, or plaintiff also, vice versa. दोनों party can give. You are hereby called upon to produce the document in order to enable me to effectively conduct the cross examination, re-examination, examination chief. अगर ये notice देने के बावजूद भी, despite the other side is not producing, then you can invoke section 89, telling the court, my lord may kindly draw adverse inference against him. Huh? My Xerox copy, which I am producing, may be taken on record. So presumption court bolegi, the court shall presume every document called for and not produced, attested, stamped, and executed in the manner required below. The court will presume all the document. 114G के अंदर court will draw presumption. The document is not producing because that will go against him. That is another presumption that you learned it earlier. I won't be repeating again. Section 114 clause G. पढ़े चुके हमने. Now the third provision, which is a very important weapon in the hand of the court, is relating to notice is please see the provisions of section 162. Check करो आप. See, a witness summon or produce. A summon to produce a document shall, if it is in his possession power, bring it to the court, notwithstanding any objection there may be protection to the admissibility, validity of any document shall be decided by the court. The court, if it sees fit, may inspect the document unless it refers to the matter of the state or take evidence to enable it determined on admissibility. So Section 162 come into play when the other party takes up the plea that this is a privileged document, I will not produce it. Husband and wife बोलेंगे these are privileged communication, I am not supposed to reveal it. क्रॉस एग्जामिनेशन में बोलेंगे एडवोकेट ने क्या आपको इंफॉर्मेशन दिया, ऐसा बोलने के बोला नो दिस इज अ प्रिविलेज कम्युनिकेशन, आई विल नॉट डाइवर्ज इट. Similarly, you will ask in the government of India to produce document relating to Rafale, relating to all these Pegasus. Government will take up the plea. These are matters concerning the state. It's a privileged communication under section 123, 124 of the Evidence Act. We will not produce it. So that is the time ये objection आता है 162 के अंदर. This is exactly what Indira Gandhi had taken objection in the trial of Raj Narayan when she lost the election. And his counsel of Raj Narayan was very intelligent. That is Mr. Bhushan's father, Senior Bhushan, asked beautiful question. All of you juniors must see the trial written by the judgment passed by the trial court of Allahabad High Court. Justice Sinha Sahab, बहुत ही beautiful judgment लिखे हैं. And he has written all the cross-examination point. It's beautifully conducted. It would be a lesson to all the juniors. According to me, everybody should go to. उस judgment के अंदर Mr. Shanti Bhushan साहब asked a question on behalf of Raj Narayan to Mrs. Indira Gandhi. He totally tore her open. Completely she was at back. She would not be able to answer this question. As a Prime Minister of India, why did you come to UP and sought the surveillance? Why you took the help of your? Can you produce the record of the assembly? Can you do this? Kuch answer nahi kar pai. What a beautiful cross-examination. I was flabbergasted. You all should read that cross-examination. I would say Shanti Bhushan has been one of the greatest cross-examiner in India in the legal history, and I really adore him for that. So he said, when you take up the plea that this is a document with regard to the state, the court will decide it. So uske andar the judgment of the Supreme Court, which I will discuss in the year 1960-61, State of Punjab versus Sodhi's judgment. So another beautiful judgment written by Justice Gajendra Gatkar of the Supreme Court, supported by also Justice the other judges, beautifully written, all of them. Gajendra Gatkar Sahab has written a very beautiful judgment, Justice. So when the central government or state government or public authorities can take when privilege, when they cannot do that, is given here. And the court has a right to examine. The court, they cannot withhold it from the court of law. You actually understand. Some voice is coming. Any idea? Okay. Awaaz band ho gaya na? So, see, the court has a right to know it. Now see that now why the court has a right to know. The right from the time when 2G, 3G ke matter chale aapne, in the year 2012-13, Supreme Court was asking from the CBI directly, you produce the document in seal and all. Why? Because the court wanted to know. The government doesn't want the other side to come to know. Every day chal raha hai ऐसा, isn't it? Abhi Kerala High Court में matter चल रही थी. Central government has passed an order. A particular channel license should be revoked. They are not giving document to the other side on the ground that is the national security matter. It's a privileged document. So the court asked the central government to show to the court. They have shown to the court with a request not to divulge it to the other side. So the court has seen the order, and the Kerala High Court yesterday, I believe, has passed the order. Yes, the license has been rightly cancelled. Of course, it has a chilling effect on the fundamental right of the TV channel under Article 19(1)(e) of the Constitution. Of course, the Supreme Court will deal with the matter ultimately. So these are the provisions with regard to the notice. When notice is not obeyed, when notice is not complied with, so your provisions of section 89 will come into play. Please remember. Okay. समझ में आ गया यहाँ तक? किसी को पूछना है कि नहीं सवाल? Anybody has any problem? Before I shift to other section? Okay. Then come to play another document which is 30-year-old document is given some kind of special treatment by the courts. 30 saal purana, your grandfather wrote a will 30 years ago, died and gone. And you led evidence that these are the will of my grandfather. the signature is not visible and witnesses have seen they are dead and gone. The court normally presume 30-year-old document, a court may presume that it's correct. Unless your brother or sister, anybody takes up the plea, it's a forged document. So यहाँ पे 90 पढ़ लीजिए आप, where any document purported to be proved to be 30-year-old is produced from any custody with the court in particular case endorses proper, the court may presume that the signature and the part of the document which purports to be the handwriting of a particular person is in the person's handwriting, and in the case of a document executed attested that it was duly attested by a person by whom it purports to be executed and attested. The explanation, the documents said to have been in proper custody if they are in the place in which and the care of the person which they have, and naturally would be, but no custody is improper, and it being legitimate original, the circumstances particular case such as render the document probable. Okay, so you take up the plea. My grandfather made a will, and the witnesses were his two dear friends who were taking a walk with him regularly. 30 साल पुराना डॉक्यूमेंट है, डॉक्यूमेंट कोर्ट में रिकॉर्ड में प्रोड्यूस करने आए यहाँ पे. अदर साइड विल टेक अप द प्ली. बोगस डॉक्यूमेंट है, लेकिन बोगस बोल के चुप रह गए. उन्होंने हैंड राइटिंग एक्सपर्ट को अपॉइंट नहीं किया, सीआईडी को रिफर नहीं किया, क्रिमिनल प्रोसिक्यूशन अंडर सेक्शन 467 फाइल नहीं किया, खाली चुप बैठ के तो कोर्ट विल एक्सेप्ट द डॉक्यूमेंट एज अ प्रॉपर डॉक्यूमेंट. बस प्लीज, इफ यू वांट टू रियली challenge it properly. Number one, you tell the court to appoint an expert, handwriting expert under section 45. Make an application to the court under section 74 to compare the signature. You tell the court to refer the document to for examination by the police authorities, or file a criminal complaint under section 467, 468 that the document has been forged with a view to cause injury, injustice to you and to deprive the property. You are one of the अगर ये एक्शन लेंगे तो then the court might say that I would like to consider the objection after seeing the proceeding, and the court will not accept the document as it is. Otherwise, in the absence of serious objection being raised by the other side, the court will presume that 30-year-old document, it is come from proper custody. The document may be marked and taken as exhibit and be read in evidence. The court ka discretion hai. The trial court is given huge responsibility and huge discretion in the matter of LTPT1. So these are the matters relating to shall presume, because these are sections, remember them. तो may presume का सीख लिया आपने, 114 दिया, मैंने दिए. Then shall presume में 89 onwards से आज के जो document है. अब now the last topic of the day is conclusive proof. Before I shift to conclusive proof, has anybody question? Please put लीजिए. Because section 4 speaks of come to section 4. Conclusive proof, when one fact is declared by this act under the word to be conclusive proof of another, the court shall on proof of one fact regard the other proved and shall not allow evidence to be given for the purpose of disproving it. So this is one section, one limb of section 4, which tells you there is no need to examine further evidence to disprove the document. Unlike the case of may presume, shall presume, you have the liberty to disprove it, the presumption. You can dislodge the presumption. But in the case of a conclusive proof document, the other side is not permitted to dislodge the document unless you establish fraud. Suppose a family court has passed a decree of divorce between husband and wife. समझे ना, डिग्री और डिवोर्स हो गया. देन हस्बैंड वाइफ मरने के बाद, वाइफ के बाद भी वेल्दी लेडी, हस्बैंड बोलता है कि वो मेरी वाइफ है, उसकी प्रॉपर्टी मेरे को मिलना चाहिए अंडर हिंदू सक्सेशन एक्ट. तो द वाइफ के भाई बहन will take a stand and there is no question of he claiming a right, he is no more the husband. Divorce हो चुका था इनका, divorce डिग्री हमारे पास है. So when a divorce decree is by the court shall presume that the divorce has taken place. Because it's a matrimonial decree. Matrimonial decree, because unless you take up the plea, unless the husband takes up the plea, that the husband and wife can take the plea that such a divorce never took place. Or the wife will say that, in fact, some other lady has been set up and taken divorce. I have not signed the papers. I was not prayed that I will deal with that question. First, I will take you through what are the relevant sections in the under the Indian Evidence Act, which regard a particular document to be document with the conclusive proof, which requires no further evidence. Now, there are two sections, three sections: section 41, section 112, and section 113. हाँ? पहला section 41 खोल लीजिए. Yeah, relevancy of certain judgments in probate etc. jurisdiction. तो यहाँ पे देखिए, a final judgment, decree, or order of a competent court in the exercise of probate. Underline the word probate, matrimonial. Number 3, admiralty. Number 4, insolvency jurisdiction. सिर्फ 4 jurisdiction के अंदर, which confers upon or takes away from any person any legal character, or which declare the person to be entitled to such character, to be entitled to any specific thing, not as not as against any specified person, but absolutely irrelevant when the existence of any such legal character or the title of such person to the thing is relevant. Such judgment, order, decree is conclusive proof. Underline this word. Underline the word. It's a final judgment. The family court has given a decree that the divorce has taken place of husband and wife. Then, upon the death of any one of them, the property cannot be claimed. It goes to other heirs under the Hindu law, isn't it? Similarly, under the provisions of an insolvency jurisdiction, which is normally vested with district courts. Now Abhi is gone to the company court, alag baat hai. And earlier it was gone with the high court and presidency, small cost, the high court and the district courts under the presidency insolvency act and act. अभी banking act के अंदर insolvency में is given to company act. When a judgment is passed that so and so is an insolvent declared as a bankrupt, is a final judgment, not an interlocutory order. Because according to me, a company law के अंदर जो CLB जो order pass करता है that so and so is declared insolvent, according to me, it is a judgment recorded without giving evidence. Because वहाँ पे तो examination chief cross and because the tribunal. Because according to me, the judgment which are passed by civil courts, especially the High Court and District Court, can be used for the purpose of Section 41. But whether of the tribunal, because tribunal को evidence act नहीं लगता है. You know that, as I told you. When it is not applicable, then I don't think a judgment of a tribunal can be invoked under Section 41. That will be a moot point for discussion, I will tell with you. Because 41 के अंदर final judgment mean a final judgment only takes place when pleadings are completed, when both the parties have a right to lead evidence and cross-examine each other, where a contentious and disputed fact. A tribunal like motor accident tribunal or तुम्हारा कोई भी tribunal, including the tribunal under the Insolvency Act, company tribunal, they don't take evidence. No, because tribunal के लिए evidence act ही नहीं लगता है. So I doubt whether Section 41 is applicable to insolvency, bankruptcy court, IBC code आजकल के जो चल रही proceeding. IBC वाले कोर्ट में जो कोर्ट है, I don't think they record evidence. Evidence Act ही applicable नहीं तो क्या record करेंगे? They only pass orders on the basis of affidavits and petitions. So that is a question that which if in case you happen to come across some judgment, let me know. I will also dig it into. So Section 41, according to me, applies a final judgment and order and decree of 4 courts. Probate court. Probate is issued by under the Indian Succession Act. Number 1, the powers are with the High Court in Bombay, which is a district court in the original site, and in the appellate and the other than Bombay places, it is a district court. Only district court has power under the provisions of Indian Succession Act to issue probate. City civil court, small causes court, civil judge, junior division, उनको power नहीं है. Please remember that. In anyway, the word district court judge is used. It is a principal court of ordinary original civil jurisdiction, the highest officer in the like for in Thane mein, Kalyan mein, Pune ke andar district judge mean the head officer, the head judge, the principal officer. In the city of Bombay, please note that district court, district judge mean high court, original side exercising jurisdiction on the original side. Section 2 of the Code of Civil Procedure में लिखा गया है ये. That point you should remember it. So यहाँ पे when the High Court or a district court has given a final order, judgment, insolvency or any, so that is it is a final order. So Bombay city में के अंदर at least city of Bombay probate is given by the Bombay High Court, isn't it? Number two, matrimonial. पहले बॉम्बे हाई कोर्ट में अभी all the Muslim marriages, Parsi marriages, Christian used to come to high court. Now they have been sent to mostly family court, except the Parsi matrimonial act because the jury system is still prevailing. अभी भी high court के अंदर है. Admiralty, the shipping related matters under the marine laws. They are the orders which are exclusively passed by the high court. High court like Calcutta, Madras, and Mumbai. These are the presidency, the charter high courts, which are the courts. So under section 41, so their judgments are conclusive proof. Underline this word. You cannot be challenging it unless it is brought under section 44. 44 check karo aap. Fraud or collusion in obtaining judgment or incompetency of a court may be proved. So you can dislodge the character of conclusive proof of this document. You take up the plea that the decree of the family court is fraudulently taken. In fact, the husband and wife never went. The advocate has prepared all the document, set up bogus people, fictitious people as husband and wife, and taken a decree. ऐसा बहुत से हुआ है. Such matter has come to me. I had done. One advocate had brought to me a particular matter. I will not take the name. That my mother's divorce has been taken by my father, who is a IPS officer in Nagpur. तो मेरी mother का नागपुर कभी गई नहीं. So petition we filed in the Bombay High Court for quashing. We got it set aside and we got the order stayed. And I appeared in that matter. This happens. To deprive the property ऐसा हुआ है. So we are successful in proving a fraud in this aspect. If you take up the plea, जब मैं कोर्ट में ही नहीं गई तो डिग्री कहाँ पे? So the husband has played a fraud upon the court. किसी और लेडी को खड़ा करके he has impersonated it as his wife and got the degree passed. It's maybe a consent decree or a decree which is contested. Number one, समझे ना आप? तो यहाँ पे you can dislodge the presumption under section 41 by proving fraud in the matter. Okay, याद रख लीजिए. Yeah. Anybody want to ask me any question before I shift to other section? अभी लड़का लड़की पैदा होता है, birth of a section 112 खोल लीजिए आप, conclusive proof के लिए 112. This will also establish whether the birth of a child after so many days is a conclusive proof. Number one, the fact that any person was born, a child was born, during the continuance of a valid marriage, shadi was subsisting, marriage was subsisting between his mother and any man, mean the husband of a man, he may be married or unmarried. That lady must have been unmarried and staying with him. Or within 280 days, अगर लड़का पैदा हुआ है, लड़का लड़की 280 days के अंदर पैदा हुआ है, during the cohabitation of that woman and the other man, maybe her husband, maybe her boyfriend, maybe her living friend, whoever it is, after the dissolution, शादी दोनों का separation हो गया, there was a matrimonial discord or relationship में खटास आ गई, दोनों के relation खराब हो गए, so there is a disengagement of both, the mother remaining unmarried, separate हो गई हो, and mother remaining, वो divorce हो गया या unseparation हो गया, dissolution हो गया. Dissolution means marriage, but the husband has gone to the family court and taken a divorce. I don't want to stay with you. So during that period, लड़का या लड़की पैदा होती है within 200, then it shall be construed conclusive proof. If within that period maybe divorce हो चुका हो नहीं हो चुका हो, a matter is pending in the court of law. During the pendency of the proceeding in the court of law for divorce, if a child is born, naturally husband क्या बोलेगा, ये मेरा बच्चा नहीं है. He want to get rid of the liability. He doesn't want to pay money. He want to desert the wife. He is interested in deserting. But the law is granting protection to the wife, says that if the child is born within 280 days, the court shall, it shall be conclusive proof of that the legitimate son. The बच्चा जो पैदा हुआ is a legitimate son. दोनों का मैट्रिमोनियल केस पेंडिंग है, नो प्रॉब्लम. पिटिशन पेंडिंग है, सेपरेशन भी हो चुका है, वॉट एवर मे बी. बट द डेज यू काउंटेड, द डेज काउंटेड डिसोल्यूशन के, अनलेस अनलेस यहाँ पे one rider and one indulgence is given to the man. So he has one window kept open to challenge his order. He can take up the plea unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. When she became pregnant, I was not in India. I was working in Dubai, foreign country. अगर वो defense लेगा तो that's a valid defense. Then it is not my child. That is the only legitimate defense a husband can take. She must have become pregnant 9 months ago. At the time, I was not in India. It is not my child. I never had any sexual relationship with my wife or with the lady in question. I never, because in fact, I was out of India. I never had any access to her. तो इसीलिए आजकल courts are now asking for DNA test. DNA, RNA जो medical test which determine the paternity, ossification test भी बोलते हैं उसको, that determine the blood level से मालूम कराता है ये genes किसके हैं, ये father के हैं नहीं है. This has happened Delhi High Court in Tiwari's case. The governor of Andhra Pradesh, who was a very close associate, he has been a governor and minister in UP. Gentleman was very colorful. He used to sleep with several women. One particular gentleman went to the Delhi High Court. He is my father because my mother told me. So DNA test में कराने के बाद मालूम हो गया, he refused to take it. Then he accepted, yes, he is my son. That means the son was correct and the mother was correct. So many men in this regard are dishonest, with due respect. They use the women, and when it comes to taking responsibility and paying payment, बोलेंगे लड़का बच्चा मेरा नहीं है. They will make allegation with regard to her chastity. There are many such people are there. So unfortunately, because though the courts are now going for DNA tests, there is a clamor that many men in the society are making representation to the parliament. You introduce a DNA compulsory, no, because they do not want to discredit women. So the women's statement will be more accepted here, that yes, 230 days के अंदर ये लड़का पैदा हुआ है, legitimate. The court will presume that it's a conclusive proof. You cannot lead unless the husband can only say that, here, I was not in India. Let him prove that. But if you are in India, in the same city, the same village, you cannot escape the consequences. So you cannot lead, you cannot take up the plea that कि मैंने कभी गया नहीं, I never had a relationship with my wife. The court is not, because under Article 15(3) of the Constitution, women has got no special right. So in consonant, because in India is a country basically where men, with due respect, here are patriarchal society, and they have been dominating, and they don't allow the women to have a much greater say in the matter. So इसीलिए the parliament in its wisdom has given more weightage and leverage to the word of a woman. That is why a woman who has been raped, her statement is accepted. The man cannot retract this statement. When we deal with the rape laws, I will deal with you. What kind of evidence? A ravished woman, her statement, even if she files FIR after 1 year, 2 years, 3 years, is normally accepted, because Indian women are very shy of going to the police station or discussing about sexual matters. So courts are giving indulgence in POSCO matters में check करें आप. Normally in CRPC के अंदर, if you don't file the FIR immediately within 1 hour, 2 hour, the courts are pounding upon others and the police officer on the women, and they quash the complaint. But not in matrimonial offences, offences relating to women. Of course, to some extent, they are misused and abused by certain women, but not by all, because all laws are abused. अभी आज के दिन आप पढ़ेंगे टाइम्स ऑफ इंडिया में कोर्ट कहता है कि Section 498A has been abused like anything. You are arresting in-laws, everybody, old people. That should not happen, according to me. The advocate plays a very important role. Should not go by the what the women says. I want to teach a lesson to my husband and arrest his wife, arrest his mother, grandmother. That's very unfair. That is not so. Today's judgment to read in Times of India, it is reported at page number 7 by Justice Nazir's bench. They have passed strictures and in 498 cases. What kind of matter this is? Even earlier in the case of Arnesh Kumar's case, the Supreme Court has passed in many cases. It should not be misused and abused. Arnesh Kumar judgment came state of Bihar in the light year. Bail should be granted as a matter of course in 498 cases and dowry demand cases, which are misused and abused to a great. At the same time, it doesn't mean that the men are paragon of virtue. There are many of them are demanding. Our Indian society, almost everybody from all walks of life in all communities, everybody demanding money. लड़की के पास से तुम जेवर लेके आओ, कार दिलाओ. That is besharmi to the highest order. According to me, it should not happen. A man should not demand anything from the women's family. Nothing right. You have a right to maintain. You should maintain. At the most, you can tell your wife to secure employment and give support to the family, give tuition. Then you married a person of that nature. You wanted a wife to support you. Then why you tell her to get money from her parents? So the law is protecting in that regard to women in the matter of evidence. So 112 के अंदर, this will be a conclusive proof of legitimacy of a child when a child is born within 230 days from the day of the separation. Please note that. Huh? Only the window open for a man to challenge that. He has to tell the court, we never had access. I never had any sexual relationship with my wife. I don't know how she became pregnant. That defense he has to take and show, and he has to take DNA test to prove. Onus is upon him. If he doesn't do this, her woman's statement becomes conclusive. Please note that. If you are husband's advocate and you merely taking up the plea, मैं इसी गांव में था लेकिन मैं नहीं कभी गया, रिलेशन खराब हो गए हमारे, मैं कभी नहीं गया, I never had it, I don't know it. You prove it by medical evidence. Medical evidence is more or less conclusive now. It's coming good, 90 to 95% correct. But you have a law, you have a right to dislodge even the medical evidence, placing that by examining another evidence. Abhi rape cases mein DNA and RNA is very regular. Please note that here. Courts are determining to find out whether the allegation the girl making against the man is correct or not. इसका टेस्ट कराओ, मेडिकल टेस्ट. सीआरपीसी में पढ़िए आप जाके. It's very investigation stages के लिए. Women's statements are recorded by the magistrate. Videography होती है इसके अंदर. समझे ना आप? 164 स्टेटमेंट के अंदर वीडियोग्राफी, फोटोग्राफी होती है, and identification, doctor's test. These are all taking place. Okay. Anybody want to ask me any question before I shift to the last section of the day, that is 113? Okay, देख लीजिए आप. 113 में आ जाइए. Proof of cessation of territory. A notification in the official gazette that the any portion of the British territory has been in force, the commencement of the Part 3 of the Government of India Act has ceded to the native places, prince or a ruler shall be conclusive proof that a valid cessation of the territory took place at the date mentioned in the notification. So prior to the independence, India के अंदर almost there were 600 states. They were Rajas and Maharajas and Nawabs ruling they were called the princely states. All of you know that. So this princely state, after the Indian Independence Act, so the princely states were governed under the Government of India Act 1911 and 1935. So they were bicameral legislatures. All of you know that the legal history of India. So The India gained independence. The Independence Act was given, passed, where certain territories went to Pakistan, certain properties. So all the Rajas and Maharajas, the Gaikwad, the Nizams, the various kings and every way all throughout, they were requested and told, you please accede to the Indian territory because India is going to be a republic. A republic in the sense, only a common man can become the president. There will be a presidential form of the government. They will not be Raja Maharajas. There will be abolition of titles. No titles and no monarchy. तो यहाँ पे जो हर किसी के स्टेट देने लगे, so the accession started. So the state step by step 600 स्टेट फॉर्म होके इंडिया में अभी उस जमाने में 20-22 स्टेट हो गए थे. तो अभी जाके इधर बढ़ चुके हैं आके. तो वॉट एवर एक्सेशन टेक प्लेस, that is the court will draw a presumption that this is a conclusive proof. Abhi, recently the government of India bifurcated Article 1 and 2 of the Union. India is a union of states, isn't it? Union of states. India, what is India? Bharat. Bharat is a union of its state. So abhi, recently the state of Andhra Pradesh was split into two. Tamil Nadu, क्या नाम है? Andhra Pradesh एक हो गया और क्या नाम दूसरा? Which, what is the state? New name state? Telangana. Telangana.
Telangana.
Yeah, Telangana ho gaya. So the
Telangana.
Telangana, isn't it? So the accession has been recorded in the gazettes. वो accession record किया, it's a conclusive proof. The Nagaland में हुआ, UP has been bifurcated into two states. Madhya Pradesh has been bifurcated. All these accessions have been recorded. So the accession जब होता है, cessation of territory, ये territory जाके ये territory में आ गया, and it's a conclusive proof, and the official gazettes because are given the sanctity, the court will take a judicial notice. You learned it here under section 57 के अंदर देखे आपने, court must take judicial notice. So the court will take a judicial notice that the 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 cessation of the territory which had taken place is a conclusive proof, and the same cannot be dislodged. A Mahajan Commission has given a certificate, has given, when Maharashtra and Karnataka have been disputing about territory, government appointed Mahajan Commission. Mahajan has given Belgaum to the Karnataka and not to Maharashtra. So the commission's report is binding upon the government of India. Government has accepted it as a territory. So the state of course, the state of Maharashtra has a right to challenge it in the Supreme Court under Article 131 by filing a suit. I do not know whether such suit was filed or not and what is the outcome. You may check it under Article 131 of the Constitution of India. The Supreme Court has got original jurisdiction to try cases between states, different state and the union. Oh, hey, oh, please check it up and let me know. So when such orders are passed, the report of the commission with regard to succession are conclusive proof. Okay, this ends the topic with regard to may presume, shall presume, and conclusive proof. I have given you all the connecting section, almost half the evidence act you will learn now. Not to worry, we'll be able to complete the portion beforehand. Now, anybody has any question, please ask me before we jump tomorrow to other section. That is section 5 onwards. That is section 5 से ले लेंगे हम, that is starting with the relevancy of facts. Chapter 2 से ले लेंगे आप. Anybody wants to ask any question, any doubt, please go ahead. I would be very happy if you ask me question. If you don't ask me question, I'll be a bit disappointed. All the other two previous batches used to ask me question. Our lectures used to go for 3 hours. I must tell you that. पहले के lecture चक्कर वहाँ पे 3-3.5 घंटे जाते थे. And I don't mind prolonging your lecture if you ask me question. If you don't ask me question, I will say that you don't want to ask. You either never understood the matter or you do not want to say anything in the matter. But क्या ये? Because there are lots of questions. By asking question only you learn more. Because you may be a silent spectator. That I'm not saying you're not a good student. You will be a good student too. Some people like to keep silently march and score. Yes, Ashutosh Kumar, any problem?
Yes, sir. No, sir. No No,
समझ
sir.
में आ गया लेक्चर ना? इसका बंद करें अभी. व्हाट इज द टाइम?
Sir, it's 6:45 p.m.
ओके, इज इट ओके? वी कैन वाइंड अप अर्ली. आई वांट टू गो फर्दर. बस करेंगे.
One question from Kedar. May I
Any
read it
question
for
from
you?
anybody? And tomorrow what I am going to discuss, तो पढ़ के आइए आप. सेक्शन 5, 6, 8 पढ़ेंगे. स्पीड में जाएंगे, बताऊंगा मैं. हाँ.
Sir, there is one question from Kedar. He has asked to explain the term got up witness.
Got up witness mean somebody you जबरदस्ती पकड़ के लेके आप. हाँ. Got up witness, planted witness. क्या बोलते हैं? Somebody who has not seen the crime of the offense. जानबूझ के उसको पट्टी पढ़ा के लेके आया. ऐसा बोलो, ऐसा बोलो, ऐसा बोलो. समझे ना? He has been told to tell lies before the court of law. Like a got up document, fabricated document, a fabricated witness. A witness who does not know anything. Or he is called an interested witness who doesn't know the facts of the case. So police officer क्या करेगा? After arresting the accused, जबरदस्ती मार पीट के उसको ले जाएगा. अरे अक्यूज ने कन्फेशन कर लिया और कहा कि ये मर्डर करने के बाद छुरी छुपाया उसने कहीं जंगल में. तो रात के अंधेरे में गए हम, मे बी टू क्या नाम कल्याण, और पेन और छुरी मिली और विटनेस को कहां से लेके गया? बॉम्बे सेंट्रल से. How, why was the Bombay witness is taken to Pain and Kalyan for recovery of the article? Why not somebody from the local man? Section 100 and 101, 103 CRPC tells you it's a local independent witnesses. You take a witness from Bombay Central Station or VT Station or Kolaba, that will raise some suspicion in the mind of the court and anybody. So he is a planted witness. He is a got up witness. समझे ना आप? समझ में
Yes,
आया
sir.
नहीं? समझ में आया? और कुछ पूछना है?
Sir, Bhavya is asking a continuous question on the very same thing. If a person who submits like comes as a got up witness, will he be charged for perjury in the court of law?
Yes. Ask him questions. Where are you staying? What are you working? कहाँ पे रहते हैं आप? क्या करते हैं? What was the reason for you to all the way go from Kolaba to क्या नाम Bombay Central to? The reason? Did you ask the police as the witnesses are not available? How do you know your connection with the prosecution? ये सब चीजें कवाल करो. Only when the evidence is coming wrong, yes, you have a right to go for perjury, ना? Section 100 and perjury 192 लिख सकते हैं IPC के अंदर. 192 रेट में सेक्शन 340 CRPC पढ़े ना आपने? लास्ट ईयर पढ़े ना? 340 CRPC पढ़े,
Yes, sir.
192 ऑफ
Yes,
द
sir.
एविडेंस एक्ट पढ़े, वो भी ऑफ द IPC पढ़े. Even section 133 of the evidence act tells you when perjury can be taken. A person may refuse to answer. X 133 tells you perjury can be taken against him, though he may not be forced to give evidence. 133 check कर लो आप. Sorry, 132. Witness not excused from answering ground of answer will criminate. 132 the answer. Proviso check करो. Provided that no such answer with a witness shall be compelled to give, shall be subject to arrest, prosecution, to accept a prosecution for giving false evidence by such answer. Section 132. Proviso to section 132 is the answer of the student. Okay. Read with section 192. If you want to file a complaint, if you want to tell the court, you take action. Section 340 CRPC, read with section 195. The court itself will become the complainant. Okay, ध्यान दीजिए. Or anything else?
No, sir.
तो समझ में आ गया आपको. Okay.
Yes, sir. Yes, sir.
So we'll call it a day for today. We'll meet up on Friday now. Okay, see you. Shall we stop?
Thank you, sir. Yes, sir.
Okay,
I'm
bye bye. Good
stopping
night.
the
Good
recording.
night. Good night.